New Mexico attorney Nadia Cabrera-Mazio, and today we're talking about indemnification clauses. Indemnification is a legal term that essentially means compensating someone else for losses due to a specific circumstance or whatever specifically, but it usually has to do with that person got in trouble because of something you did under that contract with that person, or because of something that you had agreed to basically protect them from. Indemnification can look like compensation. For example, if someone is sued and is held liable for the harm that happened to the plaintiff, then they might have to pay out that money and you would reimburse them. But it doesn't always look like that. It can also look like you taking over how they handle that situation in the first place, because you're the one that's ultimately going to be liable. So you want to make sure that the situation is handled correctly and that they're making the correct arguments to maybe reduce that liability. Therefore, indemnification is a type of legal protection that one party gives to another. When I draft contracts and I'm putting an indemnification section, I put Party A protects Party B. And then I write the indemnification clause under what circumstances Party A is going to compensate or protect Party B from losses arising out of actions of Party A or whatever else they agree to. And then, because in most cases I think indemnification clauses should go both ways, I put Party B protects Party A. The indemnification, or the circumstances under which one party will compensate or protect the other party from liability, can be really limited. And in fact, they should be limited. This is something that you should think about very hard and think about what could go wrong and under what circumstances you're willing to compensate that other party. Another thing you should take into account is the time period for indemnification. A lot of times it's appropriate for the indemnification clause, along with some other aspects of the contract, to survive the termination of that contract. For example, confidentiality provisions. You wouldn't want someone to go out and speak all these confidential details to the public just because their contract with you ended. Those things you want to make sure are written in the contract as surviving termination of the agreement. Indemnification in certain circumstances should also receive the same effect. Just because the two parties are ending their agreement doesn't mean that one might not still get into trouble for something that the other party did, which they had no control over. So now that you know what indemnification means, make sure that you're paying attention to that section in your contract and ask to make changes if it seems unfair or one-sided or way too limited for what you're comfortable with, and then negotiate from there.